Hi, friends. I'm here to talk to you today about when it is necessary for a contract to be in writing. First of all, let's talk about what a contract is, because I've had a lot of people come into my office over the years and say, hey, I'm being sued, and somebody says we had a contract, but we didn't. I never signed anything. Okay, first misconception I'll clear up is not every contract has to be written, and it doesn't have to be a written document for you to legally bound by promises that you may have made. So let's talk about what a contract is. There's an offer, and there's an acceptance of that offer. Third, there's a consideration. There's something given in return for a promise. Sometimes that is another promise. I promise this, you promise that. That each promise is consideration for the other promise. Fourth, mutuality of obligation. The agreement has to be binding on both sides. If it's not a contract. And then fifth, there must be competence and capacity. So we're talking about both legal competence and mental competence. So legally, if I'm not 18, for example, I can't legally enter into a contract. So a contract I sign or orally agree to is not going to be valid. Also, if I'm clinically insane at the time, I may not have the mental competence to make a contract. It may not be possible, for example, with someone at a certain stage of dementia to make a contract because they're not of sound mind. Okay, so that's what a contract is. Now that by itself, that definition of a contract could be a written contract, but it wouldn't have to be. It could be an oral contract. And my friend Evan Nelson reminded me of our contracts professor at law school, Jim Gordon, who said that oral contracts aren't worth the paper they're printed on. Well, I guess I'll use that to answer the question, when should a contract be written and signed? My belief is every time. That isn't the law, but I believe it's wise business practice when you make a contract of any importance at all, an agreement of any importance at all, it really needs to be in writing, and you really need to sign it and make the expectations clear, and you're saving yourself a lot of potential headaches down the road with people who remember things conveniently. And I've dealt with a lot of good people who always remember everything to their own advantage. And you just don't want to deal with that. So I believe written contracts are far superior. Now, having said that, we're going to talk about when it is legally required for a contract to be in writing. There's something called the Statute of Frauds that is the law in every state. Different states have a little different twist on it here or there. I'm giving you a general education in it and not specific legal advice. But if you need specific legal advice, you might private message me. Anyway, when is a contract required to be written and signed? Number one, a contract in consideration of marriage. The most common expression of that in our time is a prenuptial agreement. A prenuptial agreement where you're sitting around with your fiance, you may feel morally bound by that. If you're sitting around talking and saying, hey, I'm going to do this during our marriage, you're going to do that, right? Yeah, we agree on that. Well, I'm going to own this item of property after we get married, and you say that's fine. Okay, none of that is enforceable unless it's in writing. So a verbal prenup can't be done. Secondly, if the contract cannot be performed within 1 year. So let's suppose I make a contract with you that I'm going to sell you something and you're going to make me payments over a 3-year period. Okay, it's got to be in writing and signed by whoever it's going to be enforced against. Okay, third, a transfer of an interest in land. That includes a home, a shed, a farm, anything which is land or the things attached to it. Transfer of an interest in land, the contract needs to be in writing and signed by the person it's going to be enforced against. Fourth, the executor of an estate promising to pay the debt of an estate out of their own pocket. has to be in writing. A related concept, a person guaranteeing the debt of another, like being a co-signer on a loan, for example, has to be a written memorandum signed by the party to be charged. And let me make one little aside on that too. Could you do it by writing something in pen on a napkin over dinner and both signing it? Yeah, you could. If it includes all of the material terms, it doesn't have to include everything, but it has to include the basic material terms. A court might take that napkin and say, that's enough. You guys wrote out the basics of your agreement, you signed it, and the court will supply reasonable other terms to enforce that contract. So the writing doesn't necessarily have to be something that's, very formal, although the more formal the better, in my opinion, but it can be anything, like I've mentioned. All right, what are exceptions to this requirement that certain contracts be in writing? Number one, part performance. So let's suppose that you and I make an agreement. I'm going to start a new hardware store and you sell widgets, and I say, I'd really like you to supply all the widgets that I'm going to need for the next 2 years. You say, oh, I agree with that. I'll supply you all you need. Here's the price. I agree. We shake hands. Okay, well, that's presumably an agreement for more than $500 worth of goods, and it can't be performed within 1 year because I said I wanted you to supply me for 3 years. But all we did is shook hands on it. Normally not enforceable, right? But now I hire a construction company and I buy land and I build my hardware store, all in reliance on the fact that you're going to supply me widgets, which I'm going to sell in my store. That could be part performance. It could be part performance if you manufacture a bunch of the widgets that I've promised to purchase. And now we've got, particularly if those are custom goods that I had made in a particular way, I'm not going to be allowed to sort of stick you with the bill for that and say, well, we didn't have a written agreement. So if there's part performance of the agreement, the courts will sometimes infer the existence of a contract even without a writing in that situation. Second and related concept is promissory estoppel. Sounds like a complicated legal term, but really all it means is that someone cannot retract their promise or their assertion once somebody else has relied on it to their detriment. So again, it might be a situation where you've agreed to sell me widgets, and I went ahead and relied on having a supplier and took steps to build my building or whatever. I canceled my contract with a different supplier because I thought you were going to do it, and did something else to rely to my detriment on your promise. Then the court will often invoke promissory estoppel and say, okay, you can't now get out of the contract just because it wasn't in writing when this person, took steps toward fulfilling expectations that they had, spent money or whatever in reliance on the agreement. So that would be another exception. A third one, which I don't really consider to be an exception to the Statute of Frauds, there's an implied in law contract for an easement across private land if you've got a landlocked parcel and you need a path to get to the main road. The law will imply an easement, both for ingress and egress as well as utilities and things like that. The reason I don't consider that a contract as such. It's an implied in law easement, and whether you've orally agreed to it or verbally agreed to it, it'll be implied in law. So Anyway, those are the exceptions to the requirement of a written agreement signed by the party to be charged. Again, for anyone who didn't catch the first part of this, I've had people come into my office lots of times over the years and say, hey, I'm being sued. Somebody says we had an agreement, but I never signed anything. Maybe that person is an employee. Well, you know, you've still got a contract with that person. You made promises. That person worked for you and took steps to do something for you based on what you said you would do. Maybe disputed what that contract was and what it meant, but it's important to know that an oral contract is a real thing. And there are there are those 6 different examples I gave you of where a contract is required to be in writing and signed by the party it's enforced against. But even there are certain exceptions. Partial performance, where one or both parties has begun performing under the contract. Promissory estoppel, where somebody has relied on the promises of the contract to expend money or whatever in preparing for the contract, and relied to their detriment. So those are important considerations. I want to encourage you. Like I said, when is it necessary for a contract to be in writing? I've given you the outlines of the law on that subject. But how would I answer that as an attorney and as a practical matter? When is it necessary? I think it's always necessary. If the contract is about anything very important, put it in writing. Spend the money, go to your attorney, have the terms and conditions laid down clearly so that everybody knows what's expected and what they're agreeing to. It'll save you a lot of headaches in the long run. You don't want litigation occurring over a large deal just because you were too cheap to pay your attorney $500 or $1,000 or whatever is required to make sure that the expectations are clearly laid out. So that's my word to the wise. I hope this was informative, and I appreciate you watching, and we'll talk again soon.